Hello everyone, I would like to thank you for being here today. Before the beginning of the session, we would like to share with you our short safety announcement about COVID-19. As you are all aware, mitigating the risk of spreading COVID-19 during the Congress requires the cooperation of all of us. In line with the COVID-19 prevention concept elaborated by our host country Japan and the Secretariat, I would like to kindly remind you of the following precautionary measures. Fill in the contact tracing information sheet found on your assigned table or seat. Maintain at least 2 meters of physical distance from each other when not seated at your assigned seat, and avoid gathering in groups. Wear your FFP2 mask at all times. You may only decide to take your mask off when you are given the floor. Do not attend the meeting if you are unwell. If you feel ill during a conversation, contact the medical personnel stationed in each conference room. These measures are in place for the safety of all of us. I thank you for your support and attention. And I shall now give the floor to the moderator of the session. Thank you very much.
Good morning, good afternoon, and good evening. Welcome to our session. It's called the 30th anniversary of the basic principle on law of lawyers. Its contemporary role and challenge. This event was co-organized Japan Federation of Bar Association, JFBA, Union Internationale des Avocats, UIA, and International Bar Association. My name is Yasushi Higashizawa from JFBA. Okay, could you show the slide now? Today, I invited distinguished speakers around the world. But before going to this, let me give you a basic background and aim of this session. Okay? Next slide, please. I posted the session material as the introduction of the session website. It's a UN Basic Principles and a call for action paper and a research report. I'll give you the detail from now. So, next slide, please. What is the basic principle on the law of lawyers? This document was adopted in 1990 at the 8th UN Congress in Havana. The basic principle on law of lawyers, it's consisting of 29 principles. Deal with first, people's right to access lawyers, and the lawyers' qualification, training, and discipline for lawyers. In addition to those principles, particularly Principle 16 provides the government shall ensure that lawyers are able to perform all of their professional functions without intimidation, hindrance, harassment, or improper interference, and shall not suffer or threatened with prosecution or administrative, economic, other sanctions for any action taken in accordance with recognized professional duties, standards, and ethics. People have a right to access lawyers, and lawyers should be protected in the course of furthering their duties. So, the basic principle have been a sole international to protect lawyers and their duties. However, the basic principle are by no means a binding international law, which means it's not an international treaty or other binding legal document. So unfortunately, attacks on lawyers due to their carrying out professional duties are nothing new and are still in the world. Those interference on lawyers come not only from government authorities, but also from social groups as religious or extremist, powerful political figures, adversarial powers, including business powers, and even from the media. Today, I'd like to discuss what challenges we are facing with and what we can do at the occasion of the 30th anniversary of basic principles. Actually, this year is the 31st anniversary because it adopted in 1990. But due to the postponement of the UN Congress this year, we still need to celebrate and reinforce the spirit of basic principles. So today, I invited 3 speakers, and because there's many Japanese audience in this session, so I, from time to time, make a summary in Japanese. So which might interrupt the stream of the session, but forgive me for doing that. Okay. 日本語です。今、弁護士の役割原則に関する簡単な説明をしました。これが31年前に、人々の弁護士へ対するアクセスを保障するための文書としてですね、弁護士を保護するために作られた文書です。しかしながら、これまでのところ、世界中において、政府や、あるいはいろんな様々な社会的なグループからの嫌がらせ、弁護士に対する嫌がらせや妨害などが続いています。で、こうした状況に対して、この基本原則がどういうふうな役割を果たせるのか、そして我々が直面している課題は何か、これを3人のスピーカーから話してもらいます。Next slide, please. So far, we have been taking a path to this event. For example, GFBA, IBA, and UA has published call for action papers, and which was included in the official document of UN Congress. Next slide, please. Also, GFBA issued a research report on the basic principles. It covers the legal status of principle, content of principle, and what is happening in the world, and what we are dealing with. Okay, so I stop here now. So let me introduce 3 distinguished speakers. Excuse me, Michael is already online?
Yes, he's here.
So I introduce 3 speakers. First is Honorable Michael Kirby from Australia. He is a co-chair of the Human Institute of International Bar Association, IBA-HRI. And he is also have been taking several mandates from the United Nations. He is a famous jurist in the world. And let's introduce other people first. Ms. Jacqueline Scott from USA. She is the Director General of the Union Internationale des Avocats, Institute of Rule of Law, UIA-ILAW. UIA ILO is a very core part of the UIA and dealing with rule of law issue, human rights, and protection of lawyers in the world. And the third speaker is Mr. Shyam Devan from India. He is the co-chair of the Human Rights section of Law Asia, Law Association for Asia and the Pacific. Also, he is a vice president of Law Asia. So, we gathered three distinguished speakers from three major international lawyers organizations. Okay? So, I'm going to give the floor first to Honorable Michael Kirby. Michael, are you ready to go ahead?
Yes. I pay respects to everyone in Kyoto and in particular to the Japan Bar Association for organizing this session. I am co-chair of the International Bar Association Human Rights Institute. And that body undertakes investigations of complaints from members of the judiciary, from members of the legal profession, and from all countries in the world concerning the interference in the basic rights of lawyers. Sometimes it has success when it makes representations to countries concerning interference in the role and independence of lawyers. For example, in the case of Malawi, an attempt was made by the former president to interfere in the independence of the highest courts of Malawi and of the lawyers in those courts who were making representations concerning the requirement of the Constitution of Malawi. Eventually, I think the representations by the IBA led to steps being taken to protect the judiciary, and they discharged their function, and as a consequence, a new election was taken and the presidency changed. And that change was accepted by the government of Malawi, and that was an example of how the representations by international bodies can be of help. Unfortunately, there are many cases where representations have been made to countries in our region and elsewhere in the world for the cessation of disturbance and interference of members of the legal profession. The IBA is the largest representation of lawyers in the world. It has the most members, and the Japan Bar Association is a distinguished member of the IBA, and there are many Japanese colleagues in the IBA. We have made many representations concerning the interference with lawyers, representations relating to Poland, relating to Belarus, relating to the United Kingdom, relating to Samoa, relating to Iran, to Kazakhstan, and to El Salvador. These representations are made immediately we have news of disturbance of the rights of lawyers as set out in the Lawyers at Risk principles. And as a consequence of those representations, we sometimes issue media statements which are then given widespread coverage in the rest of the world. One of the most disturbing instances was the instance of Nasrin Sotoudeh, who is a lawyer in Iran. She was representing dissenting lawyers and representing them before the courts. But in consequence of her representation of lawyers who were alleged to have removed their headscarves, the Islamic Revolutionary Court imposed extremely severe punishments on Nasrin. She was sentenced to whipping and to 38 years imprisonment, which was a completely disproportionate and outrageous sentence, and representations were made to the government and the president of Iran. So this is the kind of activity that is done by the International Bar Association Human Rights Institute. Of course, it is not perfect, and of course, it is not always effective, and sometimes it is doomed to fail. But the fact that you don't always succeed is not a reason why representations should be made. As has been pointed out, the basic principles on the role of lawyers is not strengthened by machinery for the implementation of those basic principles. It is not a treaty, and it therefore depends upon support from bar associations, and there is a real need for bar associations to be included in the basic principles so that they, who are the voice of the lawyers, whose voice itself is important, can be protected and upheld. So that is a thumbnail sketch of what the International Bar Association and its Human Rights Institute does. It works with other bodies such as Law Asia and with the Union Internationale des Avocats, and it works for the global protection of lawyers, whose protection is essential for the global protection of the rule of law and of universal human rights.
Thank you, Michael. It's a very comprehensive presentation, and which give us very much information about the activities of IBA, also the situation in the world. Let me give a time for the summary. 今、マイケル・カービー判事が言ったのは、IBA がこれまで行ってきた活動の数々です。例えば最近のものとしては、マラウイに対してですね、こちらの方で、以前の大統領が高等裁判所の裁判官とか弁護士に対してですね、厳しい弾圧を加えてくるというようなことがありましてですね、それに対して様々な形での介入活動を行いました。で、結果的に新しい選挙が行われて、新しい体制になってですね、もうその問題は解決した。ただそういった形で解決できるというのはですね、非常に少なくて、むしろ多くの国においてはですね、引き続き同じような状況が残っています。で、IBA は世界最大の法律家団体としてですね、もちろん日弁連も入っていますけれども、そういった各国の弁護士会に代わってですね、判事たちに代わって声を上げるということをやってきました。ポーランド、ベラルーシ、イギリス、サモア、イラン、カザフタン、エルサルバドルなどです。で、最近のものとしてはですね、例えばイランのナスリン・ソトンディさんの事件があります。彼女は女性の権利を擁護する弁護をずっとやってきた。弁護士としてですね。で、さらには、スカーフを強制するのをやめさせることも、事件もやってきた。で、その結果、彼女は最大38年の懲役刑を受けて、今現在まだ、刑務所に入っています。 で、そうした事件に対しても IBA は様々な形での声明、あるいは活動を行ってきました。で、こうした IBA の活動というのは決して完全に効果的なものというわけではありません。しかし、現在このベーシック、基本原則がですね、それを執行するための国際的なメカニズムがない以上ですね、こうやって弁護士団体、世界中の弁護士団体によって、その実施が支えられなければならないという状況があります。そのために IBA は、ローエーシアや UIA などとも協力しながらですね、これまでも活動を行ってきましたし、それをやっていく必要があると考えています。This is the end of summary. Thank you, Michael. Maybe later I'll pose some questions to you. So next speaker is Ms. Jacqueline Scott from UIA ILOL. So Jackie, are you ready to proceed?
Yes, I am. Okay. Good day to everyone. It is indeed an honor to be here today. I want to thank the JFBA for all of their efforts in arranging this. It is an honor to be here to discuss this most relevant topic, a topic which 31 years after its inception is as relevant now as it was then. And despite the passage of 30 years, lawyers continue to be persecuted, threatened, harassed, denied the right to practice freely, imprisoned, and even killed simply for doing their jobs. And we at the UIA IROL see cases of lawyers across the world who are aligned with the causes of their clients, who are punished for defending their clients zealously and for speaking out about human rights violations. And in addition to threats against lawyers with which we are all too familiar and which have persisted over the ages, there are new and additional threats to the legal profession that have arisen most recently as a result of COVID-19. As some states, particularly those that are anxious to avoid criticism or challenges to their policies and who wish to restrict freedom of expression and access to justice, have imposed exceptional measures that have had the effect of significantly interfering with the independence of our profession. As is the case with anti-terrorism laws, which are themselves somewhat relatively new threats to our profession, the exceptional COVID measures in too many instances are simply a pretext for sidelining lawyers who take on sensitive political or human rights cases, especially those that are critical of the government. And there is, of course, a well-founded and legitimate fear that those extraordinary measures will not cease when the pandemic recedes. So now more than ever, it is necessary to insist that any restrictions on the free and independent exercise of a lawyer's mandate should only be authorized through legal processes and mechanisms, when and to the extent necessary to protect the interest of justice, as well as proportional to the achievement of the aim that is intended, and with necessary safeguards to ensure the right to defense and due process in a manner that is practical and effective. The Union Internationale des Avocats, or UIA, as we are known, UIA is on the front line of defense of the defense, and the perpetuation of the basic principles is at the heart of our efforts. Since its inception in 1927, UIA has stood up for the protection of lawyers and the independence of the legal profession. Founded in 1927 by the bars of Brussels, Paris, and Luxembourg, UIA was established with the aim of contributing to the establishment of an international legal order and with intent to maintain permanent relations and exchanges between members of the bars of all countries across the world, so as to encourage the development of the spirit of justice and the notion of international law. In 1987, the UIA created the Defense Commission to defend and support lawyers, judges, and human rights defenders who, in the course of their professional duties, were subject to persecution simply for exercising those professional duties. In parallel with individual interventions, that is, following the cases of individual lawyers who are being persecuted, UIA also provides support to bars, bar associations, and legal organizations as those bars strive to maintain their own independence and to support and defend their respective members. In fact, following the fall of the Berlin Wall, UIA mobilized to provide support and advice to burgeoning new bar associations who were subject to the abrupt changes brought about by those political upheavals. In all of our efforts, UIA values greatly relationships that we have with the United Nations Commission on Human Rights, the Council of Europe, and the African Commission on Human Rights, just to name a few, as fora in which we can discuss and collaborate on issues relating to the protection of lawyers. And the establishment of the mandate of the Special Rapporteur on the independence of judges and lawyers provided yet another avenue to engage on the threats facing our colleagues and bar associations. And we have maintained and developed a very strong network of organizations, associations, and bar associations, including many of those who are here today, who are similarly committed to the defense of the defense and the independence of our profession. Today, the UIA statutes expressly note among the organization's priority objectives the defense of the independence of lawyers and the freedom of exercise of our profession. Nowhere is our unceasing commitment to that profession more visible than in the creation in 2015 of the UIA Institute for the Rule of Law, or UIA I-ROLL, which is a separate unit whose sole focus is to promote the rule of law and address essential human rights issues, including access to justice, the independence of the judiciary, and the freedom and independence of the legal profession, all of which are essential to the rule of law. And we have developed very effective mechanisms to offer support and defense to our legal and judicial colleagues, whether in the form of public statements that we issue, letters to government officials, gathering information, missions to various countries to be on the ground and see what's happening, filing amici brief, arbitrating disputes between and among bar associations, and participating alone or jointly with other organizations in events and initiatives designed to raise awareness about the situations of our profession. In addition to direct hands-on intervention, UIA and UIA I-ROLL have contributed significantly to the scientific works that are protective of our profession. For example, in 1987 in Quebec, Canada, the UIA adopted the International Charter of Legal Defense Rights. This text was drafted after extensive and comprehensive consultation with numerous bars and law societies, and was the first of its kind to be adopted by an international organization of bars and law societies, as it set out not only fundamental principles on the rights of defense, but also the duties of lawyers towards their clients, the protections that would attach to the mandate, and the essential rules for the organization of bars and law society. In fact, 2 years before the adoption of the basic principles, the Charter proclaimed the prohibition on aligning lawyers with the causes of their clients, and recalled that at the basis of this principle is the right of any person or group of persons to retain and instruct counsel to defend his or her interests or causes within the limits of the law. Similarly, the protections against threats in relation to the exercise of a lawyer's profession, the principles of immunity from legal process, the guarantees of freedom of expression and association, and the protection afforded to the lawyer-client relationship are clearly articulated in that charter, and in some respects in greater detail even than the basic principles themselves. And finally, the Charter addressed issues relating to the organization of the legal profession and constitutes a major resource for bar associations regarding the scope of the responsibility and functions of the bars, including in bar associations' interactions with the judiciary, in the field of cross-border services, and in the training of the public on legal matters. UIA's extensive experience over the course of these many years has, unfortunately, made it an expert on the common scenarios in which the independence of lawyers and bar associations has typically been undermined. For example, the repeated misuse and abuse of systems for granting and renewing professional licenses to control the lawyers, particularly those engaged in the defense of human rights or sensitive cases, and the abuse of disciplinary procedures to prevent those lawyers from practicing. Judicial harassment combined with the identification of lawyers with their clients or their clients' causes, whether by the authorities or by the public. In particular, we see this when sensitive cases involving terrorism, corruption, drug trafficking are involved. The use of anti-terrorist laws in particular is a widely used tool of repression against lawyers, interpreting these provisions extensively. Many authorities go so far as to criminalize conduct that falls within the legitimate defense of clients. Also, we see violations of immunity from legal process in the context of oral or written statements in the course of representation of clients. And we see prosecution by disciplinary, civil, and criminal proceedings, in particular by the attribution of comments alleged as defamatory or by proceedings for contempt of court for statements lawyers make in court in defense of their clients. We see violations of lawyers' freedom of expression, particularly through restrictions or sanctions on the use of media and social networks that are used to denounce human rights violations and judicial malfunctions. We often see these measures increase in severity in the run-up to various political elections. There is a lack of adequate protection for lawyers under threat, even in the presence of decisions that are binding on the authorities. And, of course, we see violations of the independence of various bar associations through attacks on bar associations themselves, or the establishment of parallel bar associations by the government, or the adoption of legislation that is designed to control the composition and activity and authority of those bar associations. Throughout the ongoing interventions by the UIA against these model situations, UIA continuously reaffirms the guarantees of the basic principles. Most recently, the UIA has reiterated its commitment to these principles in a call to action, which Yasushi mentioned, which was drafted and submitted to this Congress jointly with JFBA and the IBA on the occasion of the 30th and now the 31st anniversary. Notably, this call to action in an earlier form was submitted to the Human Rights Council, was actually presented by Permanent Missions to the Human Rights Council on the occasion of its 44th session. It was signed by more than 60 national, regional, and international organizations devoted to ensuring the independence of lawyers, judges, and human rights defenders, and referenced in the Human Rights Council resolution because we urged states to take specific actions, and they made a mention of it. Yet, while the basic principles are masterful in substance, as Yasushi noted, they are not hard law, and that often strips them of any power. And we cannot simply rely on their existence to protect our profession. We must actively engage and do more to protect the independence of lawyers. And we need to hold states accountable for implementing and respecting these tenets to protect judges, lawyers, bar associations. And to that end, UIA supports the adoption of a convention to make these principles into hard law. And that is something that is being considered by the Council of Europe that would codify the basic principles, provide an early warning mechanism to respond to immediate threats, and impose an enforcement mechanism, perhaps becoming a source of binding standards at a broader global level and allowing even non-member states to sign on to it. In closing, then I would like to remind you again of our responsibility to continue to fight for the universal application of the basic principles. Reiterating the statement issued by the Parliamentary Assembly of the Council of Europe in considering the possibility of a convention to protect lawyers, I now call upon all states to ensure that guarantees in relation to fundamental issues such as access to a lawyer, lawyers' access to their clients, legal professional privilege, civil and criminal immunity for statements made in the course of their professional duties, and the confidentiality of lawyer-client communications be reinforced as necessary, for it is those guarantees that are indeed the linchpin to the protection of the rule of law and access to justice for everyone. Thank you very much.
Thank you, Jackie. It's a very informative presentation. Let me summarize a little bit in Japanese. 今、UIA のジャッキー、スコットさんの話は、この31年の経ったところの状況ですけれども、昨年来の COVID-19 の下でですね、さらに状況は悪くなっている。例えば政府批判を抑えるためにですね、こういった COVID-19 や、あるいは反テロ法がですね、口実として使われていたりします。で、UIA はですね、ディフェンスオブディフェンス、つまり、弁護する人のためを弁護という形でですね、これまで設立以来、弁護士の独立を訴えてきました。で、そのために各国の弁護士会と協力関係を保ってきました。特に、ベルリンの壁が崩壊した以降ですね、国際的な活動をさらに強めて、国連や欧州評議会などと、協力し、あるいは弁護士会の間のネットワークを作ってきました。で、2013年には、今現在の ILOL、法の支配機構というものを作ってですね、法の支配と人権の活動に強化しています。実際には声明を出したり、手紙を送ったり、あるいはミッションを派遣したり、あるいは弁護士会の間での問題を仲裁したり、などという形ですね。特に2017年にはカナダでですね、法的弁護の権利に関する検証というものを作りましてですね、この中では基本原則に書いている内容と合わせて、弁護士の依頼者に対する責任ということをですね、非常に強調しております。で、その中で、弁護士の表現の自由、結社の自由、これが守られるような、状況をどう実現するかということを議論しております。実際には、独立がいろんな国でですね、弁護士会自体の独立が損なわれている状況があります。政府がコントロールするための新しい法律でですね、弁護士に対しての懲戒手続き、あるいは刑事民事の手続きと、そういったものを導入するようなですね、動きが実際にあります。で、さらに、司法ハラスメントという形でですね、汚職問題や薬物問題に対して、扱う、判事や弁護士に対してですね、司法的なハラスメントを行うというようなことも、やってきています。で、この基本原則に関しましては、先ほど私からも説明しましたように、IBA、UIA、日弁連でですね、共同声明を出しましたけれども、同じ内容の共同声明はですね、去年も人権理事会の24回期にですね、提出されています。この時には69の世界中の弁護士会の賛同署名をもってですね、提出され、その声明のことはですね、国連人権理事会の決議にも取り上げられました。で、実際にこの基本原則は残念ながら、ハードロー、つまり拘束力のある法律ではありませんけれども、それについてそれを条約化しようという動きも始まっています。例えば、欧州評議会においてはですね、その条約の起草作業が始まっています。こういった形で基本原則を世界中で普遍化していくこと、さらには条約化していくこと、それによってですね、人々の弁護士へのアクセス、弁護士の職務の保護、そして秘密特権の確保、そういったものが実現されていくのだと思います。Thank you, Jackie. So maybe later I will give you some question about this.
Sure.
For the audience, let me inform, you can use the chat room in your platform. Okay. In chat room, you can put your questions or comment to either of the speakers or speakers all. Okay. Also, for speakers, when you are not speaking, then just put a mute button. So technical problem would not take place. Okay. The third speaker, let me introduce Mr. Sham Devan. As I already introduced him, he is a co-chair of the Human Rights section of the Law Asia and vice president of Law Asia. And he is a prominent lawyer in his country, India. Okay. Sham, you have the floor.
Thank you very much, Professor Yasushi Higashizawa, for those kind words of introduction. Greetings to my co-panelists, Honorable Kirby, Michael Kirby, as well as Jackie Scott, and very warm greetings to each one of you, and thank you for this opportunity to address you on this very important milestone in terms of, as the earlier speakers mentioned, 31 years of a very, very important charter, if I may use that expression, in terms of the basic principles on the role of lawyers. As was mentioned, and Professor Higashizawa didn't say this, but while I am the co-chair of the Human Rights section of Law Asia, I have a very distinguished co-chair along with me, and that is Professor Higashizawa. So it's been it's been a wonderful term which we've enjoyed together in trying to advance human rights through the Law Asia platform. Let me just say a few words about Law Asia, which works, I feel, on a smaller scale than UIA and IBA, but nevertheless has a rich experience. Law Asia is a regional association of lawyers and judges, jurists, and legal organizations. Our membership comprises not only individuals, but very importantly, bar associations from various jurisdictions. It was established in 1966 in response to a gap for lawyers coming together and to provide an opportunity for lawyers to come together in the Economic Social Commission of Asia and Pacific region, the ESCAP region. Its strength lies in its wide membership. Law Asia's individual members and the organizations which I mentioned come from across 40 jurisdictions. It organizes conferences, provides opportunities very similar to the IBA and the UIA. And it now has, as I mentioned, a human rights section. Amongst the conferences which we organized was an inaugural conference in 2019 in New Delhi, which had participants from several jurisdictions, over 18 to 20 jurisdictions. And we had a follow-up conference planned for Kathmandu, but alas, the pandemic resulted in the cancellation of that event. The human rights section's engagement is very closely related, I believe, to the basic principles of role of lawyers, because apart from looking at and examining human rights violations in general, one of the focuses as a lawyers association has been and continues to be the interaction and the interface which human rights lawyers confront with the authorities and the peculiar challenges which they face. I will begin with one or two illustrations and to explain how these activities really matter. The first one is in the context of the Maldives, where in 2018 February, Law Asia dispatched an observer mission in which Professor Higashizawa was a part. And what triggered this was that 56 lawyers who had signed a petition expressing concern about the performance of the judiciary in the Maldives had been struck off the rolls in terms of weren't allowed to practice. And the reason for this was that they were found by the judiciary at a particular point of time to be inconvenient. Now, these 56 lawyers, apart from doing their job, and they were prevented from doing their job, constituted almost 1/3 of the practicing lawyers in the Maldives. And the mass arrest therefore resulted in virtually an institutional collapse. Then you had a situation of huge pressure being brought to bear on those other lawyers who hadn't been arrested or who weren't prevented from practicing and who sought to defend and put forth the position of these lawyers. And they too were put under great pressure. As it happened, Law Asia engaged in correspondence, and then, as I mentioned to you, dispatched a team. The team, however, on arrival was not allowed to enter the country. So there were interviews, etc., which were conducted because this really vitally concerned the role of lawyers and the manner in which they were prevented from exercising their basic rights. As it happened, while the team returned, and the effort by Law Asia was also in response to an appeal which had come from eminent members of the bar, the elections which were held in September 18 and April 19 resulted in a change of government and fortunately a change in sentiment. And we are now in a position in the Maldives where the basic principles are being used as an anchor to try and build and ensure that we have bar associations that are independent and which are able to render through their members the services which every society requires. The other case which I wish to mention was also in the context of an observer mission, a very important observer mission, which was sent to Sri Lanka. Sri Lanka was experiencing a constitutional crisis. There was a need for ensuring that there is a fair constitutional hearing before the Sri Lankan Supreme Court. And not only did individual bar associations and its members, such as the Bar Association of India, receive requests from eminent members of the Sri Lankan bar to provide support on constitutional jurisprudence, but it was also very vital and important that the entire process in the Sri Lankan court and the Sri Lankan Supreme Court be carried out in a manner that inspired international confidence. And here again, I'm happy to say that there was a role for Law Asia, there was an observer mission, and the observers reported back and stated that the manner in which the case was conducted was extremely satisfactory, and eventually, again, it resulted in the strengthening of the rule of law. When we come and notice so these are some illustrations to build on some of the other examples. Of course, there are hugely differential standards across the region. Law Asia, just as you learned from UIA and in particular from IBA, as Michael Kirby mentioned earlier, statements are issued from time to time. And these have a great impact, I believe, at two levels. I'm not so sure about the impact, the individual impact of statements insofar as government and decision makers is concerned, because that often depends on political factors, but it certainly contributes collectively to a realization amongst governments that they cannot ride roughshod over lawyers' rights and their duties to represent. But a far more important sentiment, which I believe these statements of support which are publicized render, is that it gives great strength to local lawyers and to local bar associations to continue to agitate for their rights. They do not feel abandoned. They realize the importance of this international fraternity, because oftentimes within the local jurisdiction, as we are seeing, for example, just now in the context of Myanmar, it's very, very difficult to speak out against the state and against the authorities which are engaging in a degree of repression. As far as the principles are concerned, quite apart from their ringing and inspiring language, I would like to perceive them as some sort of a draft constitution for the international legal community, if not a constitution for the international legal community. And the reason why it's important is to term it in terms of some type of constitutional document is for two or three purposes. The first is that it has a universal application, and it's in a simple language that lawyers and authorities across jurisdictions can understand and apply. I think that's important, the universality. The second issue is that it provides often a very good handle for legal reform and for new statutory changes within the law, within these jurisdictions, and it empowers and enables, it provides, if not a gold standard, it was certainly a certain minimum standard for the purposes of ensuring that lawyers' associations across regions can seek governmental legislation to engraft those particular principles into local laws. So we have it in India in the form of the Advocates Act, where a large number of these principles, the Advocates Act predates these principles, but a large number of these principles, being universal, are already mirrored in some form in this particular document. But then it comes to another level, which is the advantage that we have in India, where we have an important power of not just judicial review, but a role which judges take fairly seriously, that if they find and notice that there is a gap in the law which isn't too wide, they can come in and fill in the gap using or relying upon international principles. And I'm happy to say that the Supreme Court of India has already relied upon the basic principles of the role of lawyers. They did so, and they drew support for their reasoning in the context of disciplinary proceedings against lawyers and the extent to which those could be interfered in by judicial pronouncements. And you can have several applications of that in a jurisdiction like India, such as, say, contempt of court. And the Supreme Court of India, therefore, borrowed these principles, relied upon these principles, and applied these principles. And the advantage of something of that type is that we find that often when you have an apex court which renders a well-reasoned and a well-considered judgment, then it has a certain ripple effect. And that particular impact, therefore, extends beyond the local jurisdiction of that state. I wish to also mention a couple of points. I think COVID-19 was correctly mentioned. But I think these principles have a certain resonance and importance across jurisdictions, what I would describe as advanced jurisdictions, where you feel that the rights and the roles of lawyers are very well protected, to other ones where these roles and rights are more fragile. And this challenge comes in the context of adapting these principles and applying these principles to certain modern challenges, particularly the digital challenge. And I'll just mention a couple. I think the challenge which is posed by the digital age, where you have, in the context of anti-terrorism laws and actions being taken by the state contrary to the work of human rights lawyers, and you have situations where cell phones, computers, etc. are being summoned. And I think there is a very important necessity now, the need for proper hard law as well as judicial pronouncements to draw a line, because I think if the state authorities have access to computers and to instruments such as phones of lawyers, we will find that a large number of our privileges that we've long enjoyed, and not just privileges but rights and duties, cannot be effectively performed. I see the United Nations and organized international bar associations such as the IBA, UIA, and Law Asia having a role in this regard. The final 2 points I'll make are, one, I believe given the universal necessity for having effective justice delivery systems, let us also see and examine as to whether we can ensure that the basic principles on the role of lawyers can be used through institution strengthening for ensuring diversity. And this diversity of representation, both at the bar and amongst lawyers, I believe is extremely crucial. It's recognized at some levels, in the basic principles, but perhaps that requires to be strengthened. And I will finally end with an initiative which the Human Rights section of Law Asia has taken, which I believe has great potential in terms of its impact in the years ahead, which is for bar associations to create networks which are now, with the technologies available, fairly easy to set up. So there is a new initiative by Law Asia which creates a human rights lawyers network across the region, and we hope that each one of you can, perhaps you needn't be a human rights lawyer, all you need to be is interested in human rights, which we all are, and to participate in the activities of this, because in that manner we learn a huge amount from each other. So this is perhaps a potential direction on the way forward to strengthen the basic principles. Thank you very much.
Thank you, Sham. And you made a very interesting points, in particular in the context of the Asian Pacific regions. Let me summarize a bit. During that, I encourage you to put your question or comment in chat room, anything. 日本語でも書き込んでいただいて大丈夫ですので、チャットルームに書き込んでください。今、シャム・ディバンさんの方から発表があったけれども、ローエーシアというのは、IBA や UIA に比べると小さな団体ですけれども、1966年にエスカップリージョン、アジア太平洋地域ですね。そういったものをカバーするものとしてですね、40の法域を含めて設立されました。で、様々な活動を、特にその地域での弁護士や法律家を守る活動をやってきていますけれども、例えば具体的に最近ではですね、2018年にモルジブに事実調査団を送ったりしています。これは2017年に最高裁に改善を求める60人の弁護士たちの署名文書が理由でですね、60人近い弁護士たちが資格を剥奪されてしまったということで、背景には様々な政府機関の腐敗がありました。 で、それに対して、2018年にロエシアは代表団を送ってですね、ですけれども、入国は認められませんでした。しかしながら、そういった形で、ロエシアが動いたこともあってですね、その年の総選挙によって、政府が変わってですね、で、弁護士たちもその地位を回復するというようなことがあります。その際、この基本原則というのは、ある意味でのアンカーとしての役割を果たしました。また、最近では、スリランカでですね、大統領による違法な首相の解任などがあって、それは憲法裁判所で審理される際にですね、ロエシアはオブザーバーを送って、そして憲法裁判所が違憲判決を出すなどのですね、そういった成功を収めています。で、ロエシアが対象とする状況は、IBA や UIA とはちょっとまた違うのですけれども、様々な形でその活動にはインパクトがあります。それは大きなもので2つありまして、一つは政治的なインパクト、その政府や社会に与えるインパクトというものがあります。で、もう一つはですね、それ以上に重要なのが、やはり、弁護士がそれぞれの思いを、支援の思い、共感をですね、伝えるということの重要性です。それが現地の弁護士たちに対してですね、非常に力を、励みを与えるんだということを実感しています。特に、現在起きているミャンマーでの事態に対してですね、ロエシアも声明を出しておりますけれども、そういったものが必要になってくると思います。で、基本原則はある意味で法律家の憲法的な文書です。とても明快な文言で、普遍的な形で書かれていて、それは立法的な指針となります。例えばインドでは弁護士法の中にその多くが取り込まれています。さらには司法的な解釈の指針ともなります。インドの最高裁もそれに依拠した判断をしています。そういった意味で法域を加えた重要性があります。ただ、さらに、この基本原則に対してですね、現代的なチャレンジ、今後のチャレンジというのももちろんあると思います。その一つが例えばデジタルチャレンジ。つまり現在、オンラインの世界を通じてですね、反テロリズム、などの名目でですね、携帯電話や、パソコンなどに対しての様々な監視や規制が強まっています。で、それを防止するための仕組み、法、といったものが必要です。そういったものをですね、確保していくことも、この基本原則を発展させるものとして求められていると思います。で、いずれにしても、この普遍的なものは多様性を通じたネットワークを通じて実現する可能性があります。そうした意味で、現在、弁護士会、あるいは、弁護士の間のネットワークの重要性というものは強調してもしすぎることはありません。その意味で、ロエシアは最近、人権弁護士ネットワークというのを立ち上げました。こういったものもですね、基本原則の目的を実現するために大きな役割を果たすことになると思います。Okay, I complete the summarization. So, now the discussion with panels. So far, I don't see any questions to the speakers. So let me pose a question. So, my question is every speaker emphasized the importance of the basic principles. And it was adopted 31 years ago. And everybody recognized it's a kind of a constitutional document of for lawyers. But in reality, the principle has not been strictly abided by governments. And the governments provide very ineffective or no protection for lawyers and even attack lawyers. So why this situation is continuing? So why this is happening? I would like to listen to your observation about this situation? Why lawyers are struggling so long?
Well, if I could try to give my answer on that question, lawyers have a duty to their clients, and sometimes they challenge governments, sometimes by reminding governments that they are subject to their own local constitutional principles, and reminding them that they are also subject to international principles. Lawyers become very unpopular. Lawyers disturb the even life of some politicians who don't like that. And that's why lawyers are often unpopular, and they are unpopular if they are speaking up for their clients in terms of the principles of universal human rights. You, Yasushi, have written an excellent article, which I have read, which outlines one of the two problems. First, the weakness in some respects of the UN principles on lawyers, and in particular the weakness in not really referring to the rights of bar associations and the responsibilities of governments to respect bar associations. And that's a very important point. So that's a weakness of the current principles. But then there is the weakness also pointed out by you that there is not an international convention that makes the rules more than general principles and makes them into legally binding rules. So these are the two weaknesses in the principles, and it is not surprising that governments dislike some lawyers sometimes, because lawyers question power, and that is something a lot of governments don't like to happen. And in this dialogue, we have talked of smaller countries or less powerful countries, such as Malawi and Kyrgyzstan or Afghanistan, but very powerful countries are often the most resistant to the international principles, and that's why we need to move to binding principles in conventions. And I would like to support Jacqueline Scott today for her call, and I would like to align the IBA with the call by IUA, which was made at this conference. And I'd also like to align myself with what Mr. Divan has said concerning the obligation of judges in performing their functions to inform themselves about the legal principles, the basic principles on the role of lawyers, and to bring them into their decisions and thereby make them part of the local law where that is appropriate in the particular case. So, three things. First, your article. Everyone should read it. Second, Jacqueline Scott's call for international convention. And thirdly, a call for lawyers and judges to be aware of these principles and to help to incorporate them in their work as lawyers for clients.
Thank you, Michael. It's a very important point, and I appreciate it's a kind of very practical observation to my question. So, any other speaker want to respond to my question?
Yasushi, I'll jump right in here. I agree with Michael. I think, as he's so aptly said, governments, of course, don't want to be called to answer for abuses. I mean, plain and simple, they want to do what they want, and they don't really care about some of the, these troubling details. I do think one thing that Michael has touched on is a very important one, and I think it's education. I think it's education of judges as to not only just the basic principles and the role of lawyers, but also as to what human rights violations and issues look like. I had a very interesting experience about 5 years ago meeting with the Turkish embassy in Washington on a case involving a Turkish lawyer who had been imprisoned for 5 or 7 years. And the legal counsel told me that at that point, many Turkish judges did not understand what human rights were, did not understand a human rights violation. So I think, number one, we need to educate judges on what these issues involve, what the basic principles are about, and how they apply them. And I also think we have to educate the public as to the importance and value of lawyers. And I think this is something that we as lawyers need to work hard to do, because without lawyers, there will be no rights brought to the fore. Without lawyers and judges, there will be no rights. It is we who bring those cases, and it is judges who stand up, defend those rights. So I think it's really important to try to educate the public about the basic principles, about what a lawyer does, and how a lawyer protects the rights of all people by doing his or her job.
Thank you, Jackie. Yes, the importance of the education of judges, it's a very important aspect for the implementation of the basic principle, I believe.
If I may just come in here for a moment, I'll just build on Jackie's thought, which is that at least in certain jurisdictions, and we have this in India, we have judicial academies. We have a national judicial academy and several state judicial academies. So that's essentially for continual training of judges across all levels, and they're subject specific. So yes, I believe the basic principles on the role of lawyers should be and ought to be, and I think this is where bar associations can play a role. We could provide a manual for judicial academies as well as for law schools to engraft this, because it's been, as you have mentioned, 31 years, and this certainly requires a much greater universal education and acceptance, which can come through at least these two streams, apart from the issue of educating the public, which Jackie mentioned.
And I would like to build on something that Shyam Divan said. We've got to also consider the weaknesses of some bar associations, the weaknesses in relation to membership and the role of women, and the need for a growing role of women in the law generally, in the principles of law, in the judiciary. In many countries, this is a neglected territory. But there are also other community issues such as the role of minorities, the role of racial minorities in the legal profession, and the role of sexual minorities in the legal profession. And we have to be in the vanguard of speaking up for the principles of the role of lawyers, all lawyers, and lawyers everywhere, not just male or not just majority lawyers, not just respectable lawyers who wear lovely suits, but people who represent the poor and the disadvantaged. This is when the rule of law is often really needed. And alleged terrorists and people who have fallen victim to the COVID-19 rule regulations. I think it's going to take a long time for us to overcome some of the regulations that have been introduced to deal with the pandemic, and lawyers will have to be in the vanguard of speaking up for all people and not just the popular or the wealthy or the powerful.
Thank you, Michael. Yes, there's a additional point of view was presented is the role of women, role of minorities in the area of the role of lawyers. That would be another very important point which should have been addressed and should be addressed in the basic principles and associated documents. Let me introduce some comment and question from the floor in the chat room. Mr. Masaharu Ogawa is talking about the necessity of the binding treaties in order to put power to the basic principles. So, which has been already discussed, the importance of the putting the basic principle in some kind of hard laws. Also, Mr. Jun Sasamoto commented is a situation of lawyers in Philippines under the Duterte administration, also Turkish lawyers in Turkish situations. So he is questioning protection of lawyers also should be a kind of another international human rights standards. That's his comments. Yes, since we are now lacking of time, I give the speakers as a kind of a concluding remarks to close this discussion. Sham, could you make a comment as a conclusion in this session first? And thereafter, I will ask Jackie and Michael. Yeah.
Mute.
Concluding comments, yes.
You are muted, Shyam.
I'm so sorry. Thank you, Michael. I should just tie up my final comment using the Philippines example which has been given. I think we do need mechanisms. It's one thing, as Yasushi mentioned, that we have a statement on the role of lawyers, but on the ground, if the authorities are going to flout it with impunity, then what is to be done? So I think I see a tremendous role for bar associations setting up a methodology by which we can at least receive authentic information with regard to what is happening in terms of challenges being faced by lawyers on the ground. So it could be at the initiative of one of the international bar associations, or possibly it could be at a combined and a joint initiative. But I believe we do have, just as we have methods of assessing human rights violations amongst human rights activists, I think across the world, lawyers are facing a large amount of individual threats, and we require some methodology by which we can sift through and set out objective, verified information of the problems lawyers and the attacks on lawyers, so that there can be a concerted response and there can be a concerted reaction. I think that's very, very imperative at this moment in time, because if we fail to do so, despite all the technologies available to us, then we will be failing in our duty to ensure that across jurisdictions, some of our colleagues are not able to discharge their duties to the fullest capacity.
Thank you, Sham. All sensitive information to be shared by the Bar Association. That's a very good idea. Jackie, can you make a concluding comment?
Yes, of course. I think it is up to us as lawyers, and I mean lawyers individually, but notably bar associations as collections of lawyers, to do what we can and what we must to ensure that these principles become hard law and become effective in a universal manner. And I am always struck in the basic principles, number 14, which says lawyers, in protecting the rights of their clients and in promoting the cause of justice, shall seek to uphold human rights and fundamental freedoms recognized by national and international law. It does not say may, it says shall. And I take that as our duty to make sure that we do what is necessary to uphold human rights and fundamental freedoms. And that involves lawyers becoming educated about the basic principles, because I think there are many lawyers who know nothing about them. I think that is what Shyam has said, having bar associations that are effective and independent. But of course, that is somewhat limited in jurisdictions where bar associations do not have the authority or the wherewithal to be independent. But the bottom line, in my view, is that we as lawyers must take responsibility to make this a reality.
Thank you, Jackie. Again, yes, the role of Bar Association is increasing very important for the protection of lawyers and implementation of rule of law. Okay, finally, Michael, do you have a word?
Yes. And again, I would like to endorse what my two colleagues have said. We are all singing the same hymns because we all have a common message. Years ago, I was president of the International Bar Association. And I have long been a member of the of Law Asia. I used to be a member of IUA, and maybe I should again be a member of IUA. The Human Rights Watch, the last time I was in Kyoto before the pandemic was for a meeting of Human Rights Watch. And the good thing that is now happening increasingly was touched upon by Shyam Divan of India. All of these organizations have their own activities, but increasingly we are finding a common voice to speak where it's appropriate with a common voice for the whole world's legal professions. And we've done that recently in respect of issues in Turkey, in Philippines, and in Hong Kong, for Hong Kong in China. So there are these commonalities, and we must try to find them and speak for them. Eleanor Roosevelt, in preparing the Universal Declaration of Human Rights, insisted that this was something for all people, everywhere. And this is the message that must come out of our session. And all lawyers everywhere must speak up for the role of lawyers for all people in all countries.
Thank you, Michael. Yeah, common voice. We should and we could have all over the borders and in the world. Yes, I believe. Now, we are reaching the time of the conclusion. And I think, I believe we had a very fruitful discussion today. And the very viewpoint to enforce the basic principle has been presented in this discussion. The role of bar associations, in particularly, we at least need a kind of share authentic information of the attack of lawyers in the world. And the necessity of to have hard laws, which is already started at the Council of Europe to introduce the Convention on Law of Lawyers. Also, there's many other points. The novel challenge in the digital world. Also, the necessity of recognize and reinforce the role of minority members in the legal society. That would be a lead to the, as Michael says, we are lawyers to vanguard people's rights and society. Yeah, it's a very interesting discussion, and it is very unfortunate that we cannot invite all speakers and the audience in Kyoto this year. But we, with this new technology, can be continuing the discussion in the further. I now thank all speakers and very informative presentation, as well as the audience to join this event. So thank you. So see you soon.
Thank you very much, Yasushi.
Thank you,
That was
Yasushi.
very well done.
Shyam.
Thank you.
Thank you, Michael and
Thank
Shyam.
you. Thank you, Jackie.
Thank you, Jackie. Thank you,
Michael.
Shyam.
Thank
Bye.
you. Lovely being on this panel.
And
Same.
next
It was
next
excellent.
time in Kyoto.
Yeah,
personally.
yes, yes, for sure.
Yasushi,
Yes.
you were to take a photograph. Have you managed that?
Oh yeah. Still.
Are the others still on?
Yes, already Jackie and Mike are gone. But
Okay.
I'm sure we can have a video recording.
Okay. Thank you, Yasushi. That was very
I'll
nice.
share the links of the video recording to you.
Okay. Lovely, lovely. Goodbye. Goodbye.
Goodbye, and see you soon.
See you.